Hi guys, this is attorney Ade Omojola from Omojola Law. I've been an attorney practicing law for over 13 years. My areas of focus are litigation, immigration, domestic violence slash family matters, child support, child custody, etc., and DUIs and DWIs. Today, I'd like to discuss with you uh, the issue of attorney fees. By the way, you can check us out online. Just type in Omojola Law into your favorite search engine, and you see our website. We're very easy to get in touch with. So today, I'd like to discuss with you the issue of attorney fees. In the state of New Jersey, we are required to state that each attorney has to state the hourly rate by which they charge. However, you can also charge a flat fee. So most attorneys will tell you that their hourly fee is X, and you sign a retainer agreement, you pay a retainer fee, typically about $10,000, and then they begin to work and they deduct the hourly rate from the retainer fee that is in a trust account. That's one way to go about it, and most attorneys will function that way. There are some areas of law where the work is done as a flat fee. For example, immigration, right, is a very common area where petitions and other types of work are handled on a flat fee basis. However, with my practice, I do not like to use hourly rates to, I don't like to charge hourly rates. The reason for that is because it creates an incentive for the attorney to extend the work as much as possible in order to generate income, generate attorney fees. So figure if you're charging an hourly rate, whatever the hourly rate may be, it incentivizes, right? And not all attorneys do this. Some attorneys are very straight by the book. They work X amount of hours and they solve the problem and they move on to the next case. However, there are cases where the attorney has an incentive to extend the case for as long as possible in order to generate as much as possible hourly fees. So, in order to avoid that temptation, right, what I do is I have an hourly rate, but I use the hourly rate to calculate, I estimate how many hours I believe the work is going to take based on my experience over the years. And I say, this work, I estimate maybe it might end up a trial, we might settle, discovery, whatever the case may be. I said, this work, this is going to cost, this is my estimation is this much. Based on my hourly rates multiplied by X amount of hours, the estimation is this much. What that does is the client knows exactly, as on a flat fee amount, exactly what they're paying. Not a penny more, not a penny less, right? They're able to budget, they're able to make arrangements, and they're able to do what they need to do. I can share one experience that can help make sense of this. So I had a case here in New Jersey with a client who had a multi-family unit property, and it really was their retirement kind of income. They would rent out the bottom floors for commercial stores, and the top floors were used for residents, people who lived there and paid rent. And it was the income from the property, the rental income was really the client's nest egg. So along came a fire and burned the entire house to the ground. It was so bad that the city had to tell them to demolish whatever was what's left of the building because it was a hazard. It was like an attractive nuisance. And so the insurance company was willing to pay because obviously there was a fire, the value of the building. The insurance company was going to pay them probably around $600,000 or thereabouts, maybe even more. And I think it was probably more like 700,000, close to 800K, if I recall correctly. But the property had a mortgage, and the mortgage had a clause that in the event of a fire or whatever, the bank has, gets to decide whether they want to rebuild the building or just cash out and pay off the mortgage and be done with it. But according to the contract, the client still had an opportunity to rebuild if they applied and demonstrated certain things. So the bank was giving them a hard time because they had a windfall. Here was a 30-year mortgage that would be paid off within a few years or immediately due to the windfall from the insurance company paying for the fire damage to the property. Except my client wanted to rebuild the property, and continue using the property as their income. So there was a situation there that required an attorney to represent my client to figure it out. So, well, in the course of the work, looking through the documents and looking through the transactions and just looking at the entire situation, it occurred to me that there was a possibility of some funny business going on because the bank seemed so, should I say, desperate to to just not rebuild. It should have been a difference. Just one account. So they had a lawyer, and I was communicating with the lawyer, and I said to the lawyer, we have concerns here, and my client is upset, she's angry. They are considering to go to the authorities, which would be the Department of Banking and Finance, or Department of Banking and Insurance, to file a complaint. Said this bank is engaging in what they suspected were malpractices, and which could be fraud, etc., which would potentially result in an investigation of the bank. No bank wants that. You don't want the authorities coming into your business, looking through your books, doing an investigation. It could lead to issues. So I wrote a letter and I stated our legal position, the clauses in the contracts, etc. And I sent it to the attorney and I said, by the way, we would like to settle this situation. And my client is eager to solve this issue. And I let them know that the client is considering going to the authorities because they feel like something funny is going on here. You would think that the bank would reconsider and say, let's settle and be done. But they did not. 3 days went by, 5 days went by when he heard nothing from them in response. And I said to my client, we haven't heard anything. And so they decided to forward the email that I wrote to the attorney. They forwarded the email to the bank's vice president. And within 24 hours of my client forwarding the email to the bank, we got a phone call. Let's go to the meeting. We went to the meeting. We had a discussion. They settled and they paid out the funds. That building has been rebuilt. My client moved on with their lives. They enjoy their retirement. But the point is, the attorney for the bank knew. They knew that my client was angry and upset, and that and that they felt like they were being, jerked around, and they were considering going to the authorities because they were convinced that there was something wrong here, some kind of malfeasance. But the lawyer and the law firm had an incentive not to forward that information to the bank. Now, I'm not saying the bank did anything wrong, but you don't want the regulatory authorities looking into your business. It complicates things. It increases attorney fees. It can be messy. But the lawyer had an incentive not to communicate information to the vice president of the bank, because if the authorities came in and did an investigation, they would hire the firm, and might multiply the attorney fees. So that's just one example to indicate that sometimes the temptation to elongate cases, to not solve the problem, does exist for attorneys. Now, to eliminate that temptation, I utilize the hourly rate to calculate a flat fee, which I communicate with the client, and we put it in paper, sign, they pay, do the work, solve the problem, on to the next client. That's how I operate. Omojola law.